Alrighty, so this is fresh. This is new. Trakisha, come back. All right, we're going to look at this Ashleigh Merchant letter again, courtesy of Thugger Daily. So big shout out to the Honorable Thugger Daily. Lots of vouches there in the chat. What do we have? So this is from Ashleigh Merchant. State v. Williams et al. Issues with proposed testimony of Martinez Arnold. Dear Judge Whitaker, I represent Martinez Arnold, Mr. Arnold, a former defendant in the above matter. I am submitting this letter in anticipation of Mr. Arnold's upcoming testimony. The state recently advised me that the state intended to call Mr. Arnold today, October 16th, 2024. Yesterday, I was advised that he will not testify today and will likely not be called for, quote, several weeks, but that they would try to let me know by next week. Mr. Arnold originally agreed to testify when he entered into his plea in December of 2022, now approaching 2 years ago. Mr. Arnold has kept in constant contact with me over these past 2 years to make sure that he would be available whenever the state might call him as a witness. The first time that I was contacted by the state about Mr. Arnold being called as a witness was August 13th, 2024 by Adrian Love. Miss Love asked if I could not appear with Mr. Arnold, if there was anyone who could serve as stand-in counsel for me. Oh, in your dreams, Miss Love. I informed Miss Love that I was not willing to allow any stand-in counsel to stand with Mr. Arnold during his testimony, and I asked for Miss Love to give... Okay, so we want to zoom in. This is a little tiny. It looks like it's like kind of cut off on the StreamYard stream. Let me see. All right, we'll work with what we've got. Sorry, it's a little small. I'll move myself up here. To give me some general indication of when Mr. Arnold's testimony would be needed. On September 4th, 2024, the state told me Mr. Arnold was needed within the next few days. I immediately emailed Miss Love and Investigator Long with the few dates for which I had leaves of absence on file for September, and asked for the state to provide me with an anticipated time frame for when they might call Mr. Arnold to the stand. What interesting timing that that's when they suddenly want to call Martinez Arnold, right during those leaves of absence. Really add some credence to the idea that maybe they knew Melnick would be gone when they tried to put Copeland on the stand. I received no response by email, but Miss Love called my cell phone the evening of September 11th, 2024. Oh, why don't you want to respond by email? And also sent a text message asking me to reach out to Investigator Long about the timing of Mr. Arnold's testimony. I responded to the same email chain, providing all the dates that we were available and the few dates that I was not available. Miss Love indicated that she would be calling Mr. Arnold as a witness in September, so I wrote Miss Love and the court about the 5 days for which I was on leave in September. Mr. Arnold was never called as a witness during this time, and no one from the state ever updated me on when Mr. Arnold might be called as a witness until last week. Now, that's we saw that first letter. On October 8th, 2024, Investigator Long emailed me and copied Mr. Adam Abady, and not Miss Love, about Mr. Arnold's testimony. We were told Mr. Arnold would be called as a witness sometime mid to latter part of the week of October 14th, 2024. We were asked to meet so the state could give notice of his impending testimony. I provided a very detailed response advising the state that I could have Mr. Arnold testify beginning October 14th, 2024, and any time through October 18th, 2024, and beginning again on October 22nd, 2024, through October 25th, 2024. Since Investigator Long... Oh, is it not? Oh, I'm on the wrong page. I'm sorry. 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 It's because it was a different image. I never switched to the one that... No wonder it looks smaller on your screen. Sorry, you guys. All right, so where was I? My bad. On October... Wait a minute, we were up here. Okay, so we'll start here. Since Investigator Long had mentioned in his email wanting to provide notice of Mr. Arnold's impending testimony, I drafted my October 9th, 2024 letter to Ms. Love and copied all parties, including the court, to clarify that Mr. Arnold was not avoiding service of any subpoena and intended to testify if called as a witness, but that we just needed some accommodations, such as notice to ensure that I was able to accompany him for his testimony as his attorney. On October 9th, 2024, Investigator Long emailed me that they would provide a date for Mr. Arnold's testimony within 48 hours. He also said that they would provide me with anything the state wanted Mr. Arnold to review prior to his testimony and answer my question about whether the state intended on asking Mr. Arnold any additional questions that would involve his Fifth Amendment privilege and or grant of immunity. On October 11th, 2024, Investigator Long advised that Mr. Arnold would be called as a witness on October 16th, that's today, but that they would keep me posted as the trial progressed. He also advised that Mr. Abatey would be responding about whether there were any prior statements the state intended to use to refresh Mr. Arnold's memory and whether the state intended to ask any questions outside the proffer he provided. Okay, so he gave a proffer for his plea that might implicate immunity or Fifth Amendment concerns. In the interest of expediency and let me go to the third page and make sure I share it correctly, and to avoid wasting the jury and court's time, I previously had asked the state to send me any prior statements the state may wish to use during Mr. Arnold's testimony. On October 14th, that's Monday, I wrote Investigator Long and Mr. Abatey to confirm that Mr. Arnold was being called at 9 a.m. on October 16th, 2024, and to again ask about those two outstanding questions regarding prior statements and questions outside of his proffer. In response, today, October 15th, 2024, Investigator Long responded that Mr. Arnold's testimony would not be needed this week and that the state did not anticipate his testimony taking place in the next few weeks. He wrote further, I do not have a date certain as of now. Mr. Arnold and I have now been, quote, on call since January of 2023. While we realize that trials are sometimes unpredictable, we have been available for the past 22 months. Now moving into November of 2024, I am specifically set for a jury trial the week of November 18th, 2024, and will be on medical leave beginning November 22nd, 2024. Given how other witnesses have been required to testify with, quote, stand-in counsel, Mr. Arnold is very concerned that the state is purposefully delaying calling him to the stand so that he will be denied his right to have his counsel of choosing, the same counsel that negotiated and is familiar with the terms of his plea. I am kindly asking the court to instruct the state to advise me whether, in fact, it intends to call Mr. Arnold at all so that we can avoid any unnecessary waste of the parties and the court's time and resources. Whew. If the state still intends to call Mr. Arnold as a witness, and to the extent the court can address potential evidentiary and privilege issues before they arise, and to expedite Mr. Arnold's testimony in the presence of the jury, Merchant is speaking Whitaker's language here. Expediency, trim out the stuff that can be done outside the presence of the jury. Smart. And I'm sure Merchant values the same thing, but I'm just saying, like, this is like probably music to Whitaker's ears. I believe advising the court of the history with regard to Mr. Arnold's plea negotiations and plea agreement, here we go guys, would greatly assist the court in ruling on potential issues. Factual and procedural. History regarding Mr. Arnold's plea. So this sounds like a little tea. I'm gonna get some tea. In 2024, Mr. Arnold was charged in indictment 14 SC 131032, to which he pled guilty to a misdemeanor and completed his sentence on February 29, 2016. In 2015, Mr. Arnold was charged in indictment 15 SC 140116, to which he pled guilty under the First Offender Act and completed his sentence and was discharged and exonerated on November 1st, 2021. Mr. Arnold was able to complete the foregoing sentences without a felony conviction on his record. Despite this, in 2022, Mr. Arnold was arrested and charged for the same two underlying criminal acts from 14 SC 141032 and 15 SC 140116 in the current RICO indictment. That's not surprising. That's another cliche in this indictment. And held without bond in the Fulton County Jail. Despite having been able to successfully complete probation for both underlying offenses and move forward without a felony on his record, Mr. Arnold was nevertheless denied bond. Who's surprised? Who's surprised? Having little recourse, Mr. Arnold attempted to negotiate a plea in connection with the RICO indictment that okay, we're on the right page on the screen. Yeah, we're scrolling. We got this. Let me take a sip of some water. Holy moly. Love Ashleigh Merchant, but ooh, she is thorough. And allowed him to finally be released from the conditions of what jail, you guys? What jail? Rice Street, Fulton County Jail. Notably, while the state and Judge Glanville both were unwilling to grant Mr. Arnold a bond, they were willing to let him be released on probation, provided that he provide testimony sought by the state. Mr. Arnold, however, was unwilling to make all of the statements that the state sought, so Mr. Arnold was again sent back to the Fulton County Jail to languish without a bond. After further and deliberate negotiation, the state agreed to accept the statements Mr. Arnold could swear to under oath and agreed to release Mr. Arnold on probation once he made those statements and agreed to testify for the state about those statements. Mr. Arnold agreed only to the specific statements set forth in his plea agreement, and he was very clear that he intended to retain his right against self-incrimination under the Fifth Amendment to the United States Constitution should any party seek to question him about any matters outside the specific statements contained in his plea proffer. On December 16, 2022, Mr. Arnold entered his plea, which allowed him to remain on probation. A copy of the plea colloquy is attached here too. Since the entry of this plea, Mr. Arnold has been in full compliance with the terms of his probation, for which reporting is set to terminate in December of this year. The state has not suggested Mr. Arnold has not complied with the terms of his probation, nor could it. Also, as noted above, Mr. Arnold has been ready to testify within the confines of his plea agreement. Recently, the state called one of Mr. Arnold's co-defendants to testify pursuant to his plea agreement. This witness did not receive a grant of immunity for his testimony, and unlike Mr. Arnold, apparently did not retain his Fifth Amendment privilege when he entered into his plea agreement. After this witness testified, the state filed a motion to revoke his probation for what the state believed was a violation of the terms of his probation. The state alleged that the witness, quote, directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during his plea hearing. The state then argued that this witness had the opportunity, at the time he took his plea, to correct or clarify any statements in the factual acknowledgement before affirming their truth under oath. Mr. Arnold has serious concerns that the state may, without any authority, attempt to do the same thing with Mr. Arnold. For this reason, Mr. Arnold wishes to advise the court, in advance of his testimony, why such an action by the state would be improper and illegal. As an initial matter, when Mr. Arnold attempted to correct or clarify the statements contained in his original factual acknowledgement, he was told if he did not admit to the statements as written, he would be sent to the Fulton County Jail, held without bond, and be placed on trial without his co-defendants. Let's read that again. When Mr. Arnold attempted to correct or clarify the statements contained in his original factual acknowledgement, he was told if he did not admit to the statements as written, he would be sent back to the Fulton County Jail, held without bond, and be placed on trial with his co-defendants. Mr. Arnold continually explained that he could not swear to all of the statements the state wanted him to swear to in the factual acknowledgement. Notably, after Mr. Arnold was willing to return, and hold on, we gotta go to the second tweet. So where were we? Was willing to return to the Fulton County Jail and stand trial. Let's make this readable. The state amended the factual acknowledgement to remove those statements for which Mr. Arnold had no knowledge. In other words, the parties specifically negotiated the scope of the factual acknowledgement to significantly narrow the potential scope of Mr. Arnold's testimony, which included a separate constitutional right to remain silent. We are writing to advise the court and the state, outside the presence of the jury, that if the state intends to call Mr. Arnold and ask him questions about facts that are not contained in his plea proffer, or questions that are worded differently from the statements in Mr. Arnold's plea proffer, and then attempt to use those statements against him, as it has with another witness, in an effort to revoke his probation, Mr. Arnold will assert his Fifth Amendment right against self-incrimination and will refuse to answer any such questions. Mr. Arnold's assertion, this is bolded. Ashleigh Merchant said bold in italics. Mr. Arnold's assertion of his Fifth Amendment rights, however, which was specifically contemplated by the express terms of his negotiated plea agreement, cannot be used to revoke his probation or hold him in contempt. In addition, at no time between the date of Mr. Arnold's plea and the present has anyone from the state suggested to me that Mr. Arnold would be offered immunity for any testimony he may give. Nonetheless, based on the state's history of using immunity to force additional witness testimony in the middle of trial, I outlined below several issues for the court's consideration prior to Mr. Arnold taking the stand. Oh, I love this. Oh, I love it. Mr. Arnold has no faith in any immunity agreement that the state might put forth in this case, and which has been offered to other witnesses to compel their testimony under the threat of incarceration, without assurances from the court that this immunity will extend to the state's attempt to revoke his probation if they do not like how he answers questions. Footnote here says the grant of immunity may not be conditional, and therefore the state may not condition a grant of immunity on the testimony of the witness being, quote, full, quote, complete, and, quote, truthful. That's Corson v. Hames. To be a valid grant of immunity, the state must make a written request, and the court must make a specific finding that the witness's testimony was necessary to the public interest. Furthermore, we're back up here. Mr. Arnold has no faith that the state will not use whatever he says, no matter whether he has an agreement from the district attorney for, quote, immunity against him, if they do not like how he testifies on the stand. Whew. This paragraph reads with the same sentiment the chat has. This footnote says, the state recently filed a motion to revoke a witness's probation because it did not like how that witness testified on the stand. Mr. Arnold's constitutional protections, much like a promise of immunity, ring entirely hollow when the state refuses to honor them. And we have a footnote here that I think goes to another page. So let's get that footnote first. Where is the third footnote? Okay, I don't see a footnote 3. I don't see it. I don't see a footnote 3, you guys, so I'm going to keep reading. With no guarantee that the state will not try to revoke Mr. Arnold's probation or charge him with another crime based on these same allegations, or deny him bail, or require he remain in unconstitutional conditions. And we'll get to the next page. Mr. Arnold will only answer the questions specifically negotiated and set forth in his proffer. In other words, he is asking this court, to make the state honor its agreement with Mr. Arnold and not allow the state, as it has in the past, to change the terms only after it is unhappy with the testimony. To be perfectly clear, based on the express terms of his plea agreement, the state may only question Mr. Arnold to the following. Mr. Arnold is a member of the Rollin 60s Crips. Mr. Arnold became associated or affiliated with YSL in 2015, but not that YSL is anything more than a record label, so he does not have to testify that YSL is a gang. Mr. Arnold committed the other incident for which he pled guilty to in Indictment 15 SC 140-116, and again in 2022 in this indictment. Mr. Arnold committed the other incident for which he pled guilty to in Indictment 14 SC 131032, and again in 2022 in this indictment. Mr. Arnold was present on May 9, 2022, when a search warrant was executed, and he does not claim ownership of any of these items the government claims to have discovered during the search. This was Jeffrey Williams' home in Sandy Springs. Mr. Arnold also acknowledged that YSL, which he knows as a record label, has the following, quote, identifiers: clothing with YSL or slime, pendants with letters YSL or slat, colors is green for slime, seen YSL members use one or more hand signs, language that members of YSL use includes slat, which means slime love all the time. Some of the language includes calling each other slime. Symbols that YSL uses includes a green heart and a green snake. As explained above, as to any other topics or questions, Mr. Arnold intends to assert his right to remain silent under the Fifth Amendment. The Fifth Amendment protects Mr. Arnold against any statements that potentially could be against his self-interest. In the RICO indictment, the state has alleged that certain non-criminal acts were overt acts in furtherance of a conspiracy. Therefore, this is a great, oh man, this is great from Ashleigh. She's saying the way you're trying this case and the way the RICO statute works makes it necessary and probably highly suggested for anybody to use their Fifth Amendment for anything outside the scope because you're trying to charge anything under the sun. So what does Ashleigh go on to say? Therefore, any statement by Mr. Arnold, even as to a non-criminal act, could be used by the state to demonstrate an overt act that could be used potentially to prosecute Mr. Arnold. I love this. In that scenario, Mr. Arnold would be forced to remain, yet again, in the Fulton County Jail without bond. Such an action by the state would be an obvious attempt to strong-arm Mr. Arnold into providing additional testimony. And it continues on another page. And this is the last page, you guys. Even though the state agreed to the terms of his plea offer, knowing full well to what Mr. Arnold could testify. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege against making any such statements. I think that's a typo. He intends to assert his Fifth Amendment privilege against making any such statements that are not covered in the agreed upon proffer, since any statement, as the state argues, can be used against him as an overt act should the state seek to use the information for that purpose. Right? And my confidence that they would try is super high, that the state would try. I'm highly confident that they would try. And he is asking the court to uphold the terms of his agreement and to decline any invitation to interpret his failure to testify to facts outside of that agreement as evidence of any probation violation that could be used to rearrest him. It is also my understanding that many of the questions the state may wish to ask Mr. Arnold pertain to social media posts, musical lyrics, and videos, and friendships or associations he has. The state has denoted certain of these, quote, facts as, quote, overt acts, and continues to argue that other acts are admissible as overt acts in furtherance of the alleged conspiracy. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege for any questions about social media posts, musical lyrics and videos, and his friendships or associations, since none of these topics were listed in his plea proffer. Despite the foregoing, Mr. Arnold wishes to make certain that he intends to fulfill the requirements of his plea agreement and testify as to the matters outlined in his proffer and summarized above, but only those topics. Mr. Arnold wants to make abundantly clear that, based on his fear that the state will seek to revoke his probation, should the state seek testimony beyond that in his proffer, he only intends to respond to those specific questions, and only if they are worded in the same manner they were posed during Mr. Arnold's plea proffer. If the state intends to inquire into any facts beyond the scope of his plea proffer, Mr. Arnold is providing the court and the state with notice that he intends to assert his right to remain silent, a right he specifically protected in his plea agreement. I trust this history of the negotiations regarding Mr. Arnold's plea and summary of Mr. Arnold's position on recent issues that have emerged in the context of other witnesses will assist the court in evaluating these issues should they arise during Mr. Arnold's testimony. We happily invite the state to outline its position for Mr. Arnold, the court, and the current defendants so that everyone is on the same page before Mr. Arnold's anticipated testimony, so as to ensure his testimony can be taken expeditiously, fairly, and in accordance with the terms of his negotiated plea, and without a violation of Mr. Arnold's Fifth Amendment constitutional rights. Should the court wish to hear from Mr. Arnold on any of these issues in advance of his testimony, I'm happy to address them at the court's pleasure. Yeah, we would be happy for that too. Call her in. Sincerely, Ashleigh B. Merchant. And then she sends it to all the parties. And thank you, Drea, for the Google Doc link. Big shout out to Drea in the chat. What do you guys think? What do you guys think? I mean, that was a lot, but like, well worth it. You know, I'll lose my voice to read a Merchant letter. No, but seriously, shout out to Ashleigh Merchant. And I think the state doing what they did today in changing, oh, we don't want to call her. We want to try to call her maybe in November when she's not available. Maybe that's going to backfire because now all of this is in Whitaker's ear as we have that hearing approaching for Mung Tung's plea deal, the revocation. So, I mean, like, good job, state, I guess. Like, oh, man.